We are less than 24 hours away from an historic arraignment for the former president, now charged with his second set of federal crimes. He'll face a judge tomorrow as part of the special counsel's investigation into a plot to illegally overturn the 2020 election to try to keep Mr. Trump in power. A key part of it all, the so-called fake elector scheme. You may have been hearing about it, right? People talking about it, throwing off the phrase fake electors, etc. But in tonight's breakdown, we're explaining what a fake elector is and how this unfolded. You probably know how a presidential election works. Voters in all 50 states head to the polls to choose who they want as president. If enough voters back a certain candidate, that candidate gets electoral college votes from that state. The winner needs 270. That's the magic number.
Here's the road to 270.
So that's what you see on TV. You typically don't see what happens next because it's usually a formality as members of the electoral college pick it up from there. Those members, called electors, are selected by state parties months before Election Day.
All right, friends, welcome back to Jack Mockler Family. In a federal courtroom, Trump's DOJ lawyers arrived confident to secure approval for investigating his political enemies, former officials, career prosecutors, and witnesses who had opposed him. But the judge rejected the administration's entire legal strategy, exposing it as baseless and marking a complete annihilation of Trump's attempt to weaponize the justice system against his opponents. The footage will be studied by legal historians for generations. When Trump's lawyers stood before the bench and began presenting their case, they expected the usual deference that prosecutors typically receive.
After every presidential election in December, each state gathers together electors from whichever party won the popular vote in that state. Those folks meet and send an official certificate to the National Archives and to Congress. They look like these, and they basically say, okay, this is who gets our state's electoral college votes. It's pretty ceremonial, except in 2020. That's when the former president and his allies got to work convincing loyalists in 7 states that they should back Republican electors in key battlegrounds won by the Democrat in the race, Joe Biden. The focus on Arizona, Georgia, Michigan, Nevada, Wisconsin, New Mexico, and Pennsylvania. Some of those so-called fake electors showed up at state capitals where the real electors were meeting. They even created phony certificates like the ones you see here. The goal, apparently, to send through this fake slate of electors to Congress, where the vice president presides over the official count. The thinking seemed to be that then VP Mike Pence could grant Mr. Trump the disputed electoral votes or send the issue back to the states, opening the door to keeping Mr. Trump in power. You probably know what happened next. Pence rejected the scheme, citing the Constitution.
They expected the judge to accept their representations, to sign off on their requests, and to let them proceed with their investigations. Instead, they walked into a judicial buzzsaw that would leave their legal arguments in shreds and their professional reputations in tatters. The judge began by asking the most fundamental question any prosecutor should be able to answer. What crimes are you investigating? And what evidence do you have that those crimes were committed? It seemed like a simple question, the kind of thing that any competent prosecutor should be able to answer without hesitation. But Trump's lawyers couldn't answer it. They stammered, they deflected, they made vague references to national security concerns. They claimed the evidence was classified and couldn't be discussed in open court.
President Donald J. Trump!
And Mr. Trump on the National Mall told his supporters the election was being stolen. It was not.
We fight like hell. And if you don't fight like hell, you're not going to have a country anymore.
Remember, by that time, most of Mr. Trump's election challenges had been thrown out in court, and his own attorney general had declared no evidence of widespread fraud. Some defenders of the former president have pointed to one historical example, they say, the 1960 presidential election. That's when the votes in the state of Hawaii were so close between John F. Kennedy and Richard Nixon, even a month after Election Day, that both slates of electors, the Democrats and Republicans, offered up their votes at the post-Election Day meeting. The big difference, as experts point out, the results in Hawaii were actually in question, something that was not the case in 2020.
They tried every trick in the book to avoid providing the information the judge was demanding, and the judge wasn't having any of it. The judge made it crystal clear that court approval for investigative steps requires the government to demonstrate probable cause that crimes have been committed. You cannot simply investigate people because the president doesn't like them. You cannot use the awesome power of the federal government to retaliate against political enemies. The Constitution doesn't permit it. Federal law doesn't permit it. And this court will not permit it.
6 top Republican officials have been indicted in Nevada for pledging that state's electoral votes to Donald Trump in 2020 as part of an illegal effort to reverse Trump's loss to Joe Biden. These so-called fake electors include the state's Republican Party chairman and national committeeman. William Brangham takes a deeper look.
Jeff, Nevada is now the 3rd state to bring criminal charges against false electors, following Georgia and Michigan. In Wisconsin, another group of fake electors settled a civil lawsuit this week requiring them to admit Joe Biden won the presidency and that they were trying to improperly overturn that result. Election law expert Rick Hasson is the director of the Safeguarding Democracy Project at UCLA's law school and author of the forthcoming book, A Real Right to Vote: How a Constitutional Amendment Can Safeguard American Democracy. Rick, great to have you back on the NewsHour. Can you remind us what these fake electors were actually trying to do, how they were trying to insert themselves into the elections process?
The judge demanded that Trump's lawyers provide some factual basis for believing that the targets of their investigations had actually committed crimes. And that's when the collapse really began. Trump's lawyers had nothing. They had vague allegations that had been fed to them by the president himself, claims about leaking classified information, claims about lying to Congress, claims about obstructing justice. But when the judge pressed for specifics, for actual evidence, for anything that would justify the extraordinary step of launching criminal investigations against former high-ranking government officials, they came up empty. One of Trump's lawyers attempted a particularly audacious argument that actually made things worse.
Sure. Well, after people vote, there's a whole procedure that takes place where the state's results are translated into electoral college votes. There's a date that the electors meet in each state. The results are then sent into Congress, and those results are counted on January 6th. You may remember that at the time that the 2020 election period came, when it was time for the electors' votes to be cast, Trump was claiming that he was actually the victor in a number of these states. What he tried to do was have Republican slates of electors who were pledged to him vote on the same day, and so that these votes could then be sent in and they would potentially be counted by Congress. The problem was that there was no authorization under state law to have these Republicans meet. These were all states where Joe Biden won and where the lawful electors were the Biden electors, whose slates were actually sent to Congress, and those were the ones that were ultimately counted on January 6th and then the morning of January 7th. Back in 2021.
So there were fake electors, as we call them, operating in 7 different states back in 2020. We have this settlement in Wisconsin. We have these charges brought in Nevada. Are there other similar investigations underway?
The lawyer suggested that the target's refusal to cooperate with the investigation was itself evidence of guilt. The judge responded with barely concealed incredulity, explaining that every American has a Fifth Amendment right against self-incrimination, and exercising that right cannot be used as evidence of guilt. The fact that Trump's lawyers were even making such an argument demonstrated how far outside the boundaries of legal ethics and constitutional norms they were operating. They were so desperate to find some justification for these investigations that they were willing to advance arguments that any first-year law student would recognize as unconstitutional. And the judge made sure everyone in that courtroom understood just how far they had strayed from proper legal practice. The judge then took the extraordinary step of addressing the elephant in the room directly. It was obvious to everyone present that these investigations were politically motivated. The targets were all people Trump had publicly attacked. The timing of the investigations coincided perfectly with Trump's return to power, and the pattern of targeting was too consistent to be coincidental. Trump was using the Justice Department to punish his political enemies, and that was unconstitutional. The judge cited Supreme Court precedents establishing that prosecutorial discretion cannot be exercised in a discriminatory or vindictive manner. When prosecutors target people based on their political beliefs, their speech, or their exercise of constitutional rights, that's a violation of the Constitution. And that's exactly what was happening here. These investigations were vindictive. They were discriminatory. They were designed to punish people for exercising their First Amendment rights to criticize the president, and therefore the subpoenas were invalid and would be quashed immediately. The judge went further and ordered the entire investigation shut down. All documents that had been improperly obtained had to be returned. All grand juries that had been convened for these political prosecutions had to be dismissed. And then the judge delivered the most devastating blow of all, a warning to Trump's lawyers that if they attempted to revive these investigations or pursue similar cases in the future, the court would consider sanctions, including referring the lawyers themselves for disciplinary proceedings that could result in them losing their licenses to practice law. A federal judge was threatening to have Trump's Justice Department lawyers disbarred for bringing frivolous, vindictive prosecutions. That's how egregious their conduct was. That's how far they had strayed from the norms of professional legal practice. And the reaction in the courtroom was stunning. Multiple reporters who were present described a moment of stunned silence that seemed to last forever after the judge finished speaking. Trump's lawyers just stood there, frozen, unable to respond. They didn't object. They didn't ask for time to brief the issues. They didn't demand reconsideration. They just stood there like they had been punched in the face because they knew the judge was right. They knew they had no legal basis for what they were doing. They were just following Trump's orders, hoping they could get away with it, hoping that no judge would have the courage to stand up to the most powerful person in the country. And now a federal judge had publicly called them out, had exposed them as participants in an abuse of power, and had documented their incompetence and corruption for the entire world to see. The video of this courtroom disaster went viral almost immediately. Within hours, it was all over social media, with millions of people watching Trump's lawyers stumble through their arguments and fail to answer basic questions. News shows were playing clips and having legal analysts break down exactly how badly Trump's legal team had been destroyed. Phrases like total collapse and bombshell ruling were trending across multiple platforms. This was a public humiliation that no amount of spin could repair. Everyone understood that these prosecutions were Trump's idea, his obsession with revenge, his abuse of the Justice Department. And now a court had stopped him, had declared his actions unconstitutional, and had publicly exposed the legal bankruptcy of his entire strategy. The president's reaction was exactly what everyone expected: pure rage, completely unhinged and counterproductive. Trump immediately went on his social media platform and launched a furious attack on the judge, calling the ruling rigged, claiming the judge was biased and corrupt, demanding that the judge be impeached. But he didn't stop there. He also attacked his own lawyers, posting that they had failed him, that they weren't tough enough, that they should have fought harder. This was insane because the problem wasn't that Trump's lawyers didn't fight hard enough. The problem was that Trump's prosecutions were fundamentally unconstitutional. No amount of aggressive lawyering could fix that. But Trump couldn't accept that reality. He couldn't admit that he was wrong, that his revenge prosecutions were illegal, that he had violated the Constitution he had sworn to uphold. So he blamed the judge, blamed his lawyers, blamed everyone except himself. And that response just made everything worse. Trump's reaction showed the entire country that he was unwilling to accept judicial rulings, unwilling to respect the independence of courts, willing to attack any judge who ruled against him. This is authoritarian behavior. This is what dictators do when courts try to constrain their power. And it confirmed everything critics had been saying about Trump, that he was a threat to the rule of law, that he didn't respect judicial independence, that he would destroy democratic institutions rather than accept limits on his power. The courtroom collapse was bad enough on its own. But Trump's response to it was even more damaging because it revealed the authoritarian instincts that had always been lurking beneath the surface. He couldn't accept that he was subject to the law. He couldn't accept that courts had authority over him, and that inability to accept judicial authority would ultimately lead to his complete downfall. To fully understand the magnitude of what happened in that federal courtroom, we need to dig deep into the specific legal reasoning the judge employed, because the analysis provided in that ruling was devastating, comprehensive, and will serve as a blueprint for courts across the country in handling similar cases. The judge began by addressing the fundamental constitutional role of prosecutors, explaining that prosecutorial power is one of the most serious powers any government possesses. The power to charge someone with a crime, to subject them to invasive investigation, to potentially take their freedom, is not a power that can be exercised arbitrarily or for improper purposes. It must be exercised responsibly, based on evidence and law, not based on political considerations or personal animus. The judge cited multiple Supreme Court cases establishing these principles. Cases holding that selective prosecution based on constitutionally protected activity, like political speech, is unconstitutional. Cases holding that vindictive prosecution designed to punish someone for exercising their rights is unconstitutional. The judge explained that these precedents apply with special force when the targets are political opponents of the president because the potential for abuse is so great. The president has enormous power over the Justice Department, and if that power can be used to punish political enemies, the foundation of democratic governance is undermined. People must be able to criticize their leaders without fear of criminal investigation. They must be able to testify against powerful figures without fear of retaliation. They must be able to exercise their constitutional rights without looking over their shoulders for federal agents. The judge then went through the specific targets of Trump's investigations one by one, noting what they all had in common. Former Deputy Attorney General Sally Yates, former FBI Director James Comey, former DOJ official Bruce Orr, several career prosecutors who had worked on Trump investigations. All of them had refused to follow Trump's orders to interfere with investigations or prosecutions for political purposes. All of them had testified to Congress about Trump's improper behavior. All of them had been publicly critical of Trump, and Trump had publicly attacked all of them, threatened them, demanded they be prosecuted. And now, after Trump returned to power, they were all being investigated. The timing and targeting couldn't be more obvious. This wasn't legitimate law enforcement. This was retaliation, pure and simple. Trump was using the criminal justice system as a weapon against his enemies, exactly what the Constitution prohibits. The judge also addressed Trump's lawyers' argument that they had evidence justifying the investigations, but couldn't disclose it because it was classified or because the investigations were ongoing. The judge rejected this completely, explaining that when the government seeks court approval for investigative steps, it has to show the court why those steps are justified. You can file materials under seal if they're sensitive. You can have ex parte hearings if necessary. But you can't just tell the court to trust you. The court has an independent obligation to ensure that prosecutorial power is being exercised properly. Trump's lawyers hadn't met their burden. They hadn't shown any actual evidence of crimes. They had made vague allegations, but when pressed for specifics, they had nothing. The judge noted that this pattern was telling. If there really was evidence of serious crimes, the government would have produced it under seal. The fact that they didn't suggested there was no evidence, that these investigations were pretextual based on Trump's political desires rather than actual wrongdoing. One of the most devastating aspects of the judge's ruling was the focus on the hypocrisy of Trump's legal position. The judge noted that Trump's Justice Department was simultaneously arguing contradictory positions in different cases. In these revenge prosecution cases, Trump's lawyers were arguing that the president has broad authority to direct prosecutions, that the attorney general serves at the president's pleasure and has to follow presidential directives, that prosecutorial independence is not absolute. But in other cases, when Trump himself was being investigated for crimes, his lawyers claimed prosecutorial independence was paramount. They argued that prosecutors were abusing their authority by investigating Trump for political reasons. They claimed the president should be immune from politically motivated prosecutions. The judge pointed out that you can't have it both ways. Either prosecutorial independence matters or it doesn't. Either prosecutors can be directed by the president or they can't. Trump can't claim immunity from prosecution based on prosecutorial independence while simultaneously directing prosecutions of his enemies. The phrase the judge used to describe this hypocrisy went viral immediately. The hypocrisy is so thick you could cut it with a knife. That line perfectly captured what everyone was thinking. Trump's legal positions were completely hypocritical, designed solely to benefit Trump, to protect him from accountability while allowing him to attack others. There was no principled legal theory behind them, just naked self-interest. And the judge wasn't shy about saying so. The judge made clear that the court could see through the transparently self-serving arguments and that such hypocrisy only further undermined the credibility of the government's position. The judge also addressed the broader pattern of Trump's behavior, noting that these revenge prosecutions were part of a systematic effort to intimidate anyone who might oppose or criticize Trump. Former government officials were being investigated. Journalists who reported critically on Trump were having their communications subpoenaed. Even private citizens who testified against Trump were being harassed by Trump supporters, encouraged by Trump's rhetoric. The judge said this created a chilling effect on constitutional rights. People were afraid to speak out against Trump. They were afraid to cooperate with legitimate investigations. They were afraid to testify truthfully because they knew Trump would retaliate. The judge explained that this is exactly the kind of abuse of power the Constitution is designed to prevent. The First Amendment protects the right to criticize the government. The rule of law requires that people be able to cooperate with investigations without fear of reprisal. Trump was destroying both of those principles, and courts had an obligation to stop him. The judge made clear that this ruling would have broader implications beyond these specific investigations. The legal reasoning applied not just to these cases, but to any politically motivated prosecution, any use of the criminal justice system to punish Trump's enemies. The judge indicated that other federal judges should follow this reasoning, should scrutinize Trump's prosecutions carefully, should demand actual evidence rather than accepting vague allegations, and should dismiss cases that appear vindictive or selective. This was a roadmap for shutting down Trump's entire revenge prosecution agenda. And Trump's lawyers knew it. They knew this ruling would be cited in every other case, would give judges a framework for blocking Trump's abuses, and there was nothing they could do about it. Trump's lawyers tried to argue that the judge was overstepping, that prosecutorial discretion was unreviewable. But the judge shut that down completely. The judge said prosecutorial discretion is not absolute. Courts can review exercises of prosecutorial discretion to ensure they're not unconstitutional. And this was clearly unconstitutional. So the subpoenas were quashed, the investigations were shut down, and Trump's revenge prosecution strategy was in tatters. The implications of this ruling extended far beyond the specific cases at issue. It fundamentally changed the legal landscape for the entire administration, making it much harder for Trump to use the Justice Department for political purposes and providing a powerful deterrent against future abuses. The professional consequences for Trump's lawyers were immediate and severe. The judge's threat to refer them for disciplinary proceedings was serious. Bar associations across the country started investigating the lawyers involved in these revenge prosecutions. Some faced ethics complaints. Some faced potential disbarment. This made it even harder for Trump to find competent lawyers willing to represent him because representing Trump increasingly meant risking your law license. Competent, ethical lawyers didn't want that risk. So Trump was stuck with increasingly marginal lawyers, people who were desperate for clients or ideologically committed to Trump, regardless of legal ethics. Those lawyers weren't good enough to handle the complex legal battles Trump was facing. So Trump's legal representation kept getting worse, which led to more courtroom defeats, which led to more good lawyers refusing to work for him. It was a vicious cycle accelerating Trump's legal collapse. The courtroom collapse on that pivotal day sent shockwaves through the entire political and legal establishment, and its consequences continued to reverberate for months afterward. One of the most immediate effects was that it emboldened other targets of Trump's revenge prosecutions. After the ruling, multiple people who were being investigated by Trump's Justice Department came forward publicly. They filed their own motions to quash subpoenas. They gave interviews describing the politically motivated nature of the investigations. They called for congressional oversight of the Justice Department, and they started filing lawsuits against the government for malicious prosecution and abuse of process. Trump's revenge agenda was creating civil liability, potential damages that would have to be paid out of government funds, and congressional Democrats started demanding hearings. They subpoenaed Justice Department officials. They demanded documents about who had ordered these investigations, and while Trump's administration tried to stonewall, information started leaking. Career Justice Department officials were disgusted by the political prosecutions, and they were leaking to Congress and to reporters. Those leaks provided more evidence that Trump was personally directing revenge prosecutions, that he was ordering specific people to be investigated and prosecuted. That created both impeachment exposure and criminal exposure for Trump himself, because using your office to punish political enemies is a crime. It's abuse of power. And Trump was creating evidence of his own criminal conduct every time he ordered these investigations. The political implications were equally significant. Democrats immediately seized on the courtroom disaster as evidence of Trump's authoritarianism. They ran ads showing clips of Trump's lawyers stumbling in court, highlighting the judge's statements about unconstitutional prosecutions, framing Trump as a wannabe dictator who was being stopped by heroic federal judges. Those ads were effective. Polling showed voters were disturbed by Trump's revenge prosecution agenda. Majorities said the president shouldn't be allowed to order investigations of political opponents, and Trump's approval ratings dropped further. Even many Republicans were uncomfortable with the revenge prosecutions because they understood the precedent it set. If Trump could use the Justice Department to prosecute Democrats, then future Democratic presidents could do the same to Republicans. This wasn't just about Trump. This was about whether the criminal justice system would be politicized permanently, and many Republicans didn't want that. They wanted rule of law, wanted prosecutorial independence, wanted to stop the cycle of political retribution, so they privately welcomed the ruling even though they couldn't say so publicly. And that created fractures within the Republican Party between Trump loyalists who wanted blood and institutionalists who wanted to preserve democratic norms. These fractures would only widen in the months ahead as Trump's legal situation continued to deteriorate. The courtroom collapse fit into the broader narrative of Trump's downfall. By that point in his presidency, he was facing setbacks on multiple fronts: asset seizures, failed bond attempts, military leaders condemning him, and now public courtroom humiliations. Each defeat made the next defeat more likely, because they all contributed to an image of Trump as weak, desperate, and on the defensive. And that image was politically toxic. Trump's brand was built on strength, on winning, on dominating opponents. But by that point in his presidency, Trump looked like a loser, someone who couldn't accomplish his goals, who was getting beaten in courts and losing support in his own party. Once that perception took hold, Trump's support collapsed rapidly, because people don't follow losers, especially in political movements built around a personality cult. If the personality shows weakness, the cult disintegrates. The courtroom collapse was one more piece of evidence that Trump was finished. And voters saw it. Donors saw it. Even Trump's own supporters started to see it. The rulings from that day would be cited repeatedly in subsequent cases, providing a legal foundation for blocking Trump's abuses across multiple jurisdictions. Other judges followed the reasoning, demanding evidence before approving investigations, rejecting arguments based on presidential authority, and protecting the independence of prosecutorial decision-making. The ruling also illustrated why prosecutorial independence matters so much in a democratic system. Trump wanted to turn the Justice Department into his personal law firm and attack squad, but that's not what DOJ is supposed to be. DOJ is supposed to be independent, to make prosecutorial decisions based on evidence and law, not based on what the president wants. When Trump tried to destroy that independence, judges stepped in. They used their authority to check executive overreach, to protect prosecutorial independence, to ensure the criminal justice system wasn't weaponized for political purposes. This judicial resistance was crucial to saving the rule of law. If judges had deferred to Trump's Justice Department, if they had rubber-stamped revenge prosecutions, then prosecutorial independence would have been destroyed. It would have been nearly impossible to restore. But judges didn't defer. They scrutinized, they demanded evidence, they exposed abuses, and they shut down unconstitutional investigations. That's how the system is supposed to work. Different branches checking each other, courts constraining executive excess. Perhaps most significantly, the courtroom collapse was a preview of what would happen to Trump in his own criminal trials. If Trump's lawyers couldn't defend revenge prosecutions against his enemies, how would they defend Trump against legitimate prosecutions of his own crimes? The same problems that destroyed Trump's revenge cases would destroy Trump's defenses: lack of evidence, hypocritical legal arguments, reliance on political attacks rather than legal reasoning. All of that would fail in court. And it did. When Trump faced trial for his various crimes, his lawyers had no effective defense. They tried the same tactics that failed that day, attacking prosecutors as politically motivated, claiming evidence was fabricated, making constitutional arguments that didn't hold up. And judges rejected it all, just like they rejected Trump's revenge prosecutions. Because courts follow evidence and law, not political loyalty. The evidence against Trump was overwhelming. So Trump got convicted on every charge and sentenced to prison. The ruling that day foreshadowed all of this. It showed that Trump's legal strategies were bankrupt, that courts wouldn't bend to his will, that justice would prevail. And that's exactly what happened. In the end, the courtroom collapse was a turning point, a moment when Trump's attempt to weaponize the criminal justice system failed spectacularly and publicly. It accelerated Trump's downfall because it showed Trump couldn't deliver on his revenge promises, couldn't bend courts to his will, couldn't escape accountability through aggressive legal tactics. The collapse was one more step in Trump's march toward total defeat. When prosecutors eventually brought comprehensive charges and courts ordered Trump's arrest, nobody was surprised. The pattern was clear. Trump was losing in every forum. Courts were holding him accountable, and the rule of law was surviving despite Trump's best efforts to destroy it. That's the lesson of that courtroom disaster, that institutions can resist authoritarianism, that judges can check executive abuse, that rule of law can prevail, and that Trump, despite all his power and threats and attacks, ultimately faced justice. The courtroom collapse was a preview, and Trump's final collapse was the inevitable conclusion. Every argument he made, every tactic he employed, every attack he launched, all of it was futile in the face of a judicial system that refused to be intimidated. The judges who stood up to Trump that day and in the days that followed are heroes of American democracy. They upheld their oaths, defended the Constitution, and ensured that no president, no matter how powerful, is above the law. The reverberations of that ruling continue to shape American law and politics. It established binding precedents that constrain future presidents, making it much harder for any chief executive to use the Justice Department as a tool of political revenge. It demonstrated that the courts remain a bulwark against authoritarianism, a check on executive power that can withstand even the most determined assault. And it provided a model for judicial resistance that has been followed in similar cases across the country. The video of Trump's lawyers stumbling and failing remains a powerful reminder that the law is not swayed by political power. It requires evidence, logic, and constitutional fidelity. When those are lacking, the case collapses. And on that day, the case against Trump's enemies collapsed in the most spectacular and public fashion imaginable. The ruling deepened Republican divisions between Trump loyalists who see courts as obstacles and those who recognize the fight as destructive. But it also provided cover for critics to cite judicial authority. The collapse was complete, prosecutors demoralized, lawyers facing consequences, and Trump increasingly isolated, unable to find competent representation or persuade courts. The judge who stood firm reaffirmed that checks and balances are not theoretical but practical constraints, proving the system works and the rule of law can survive even the most determined assault.